Several days ago, I was invited to contribute to a television show out of North Carolina around the singer R. Kelly, who was convicted at trial, sentenced to 30 years in prison. And apparently, R. Kelly is transferring to the federal prison in Butner. In advance of this TV interview, I did a little research on the case because I had never covered it. I didn't follow it. I never listened to his music growing up. In fact, the only time I heard coverage of this case, I think, is when Dave Chappelle did a comedy skit in one of his Netflix specials. So wanted to feel prepared for the interview. I did some research. And when I read about how poorly he prepared for sentencing, I read it and I thought, this is a teachable moment. If you are going through this system, if you have pled guilty or you have been convicted and you have a probation interview coming or a sentencing hearing, you can learn from the terrible, horrific mistakes R. Kelly made through sentencing. The question is, are you going to take the advice or are you going to cower and not do anything? That is up to you, but I am here to teach and get you to take the appropriate action. Now, so many defendants, whether you plead guilty or are convicted at trial, are told by the lawyer to scale back. Don't say anything. Let's not give too much ammunition or information to the government for fear that it could hurt you. Now, of course, that information doesn't align with what we've learned from judges. So a huge part of thriving through the system is exercising and using your own judgment. That's why the videos we have filmed with federal judges are so impactful, because you're hearing it directly from them. I've spoken with judges on stage and I share those insights with you. You've got to take this information, assess it, and act. So think about the consequences that would follow if you don't seek to change the government's version of events. You sit down for a probation interview. What does that stakeholder or probation officer most likely have? Well, they're going to probably have spoken to the prosecutor. They're going to have your indictment, your conviction, any press releases, victim impact statements. Overall, they're not going to think that you're a great person based on the government's version of events. Now, you might be thinking, Justin, but I retained a former U.S. attorney. Big deal, by the way. I don't care if you have a lawyer that graduated last in law school and barely passed the bar. If they're open to collaboration and thinking and teamwork and putting their ego aside, I don't care. Neither should you. I hear our team hears that every day. I hired a former AUSA. Well, what does that mean? I'm not really sure, but it's on their website. Okay, great. But are they into mitigation? Are they letting you do the work? Do you understand what you need to be doing on a daily basis? Are you told to scale back and wait? It's too early to prepare, which is what we frequently hear. So I hope you have a great lawyer. Regardless, you've got to do the lion's share of the mitigation. So if you're not doing this work leading up to a probation interview, and if you work under the mistaken presumption that, well, my lawyer's going to say it, my lawyer's going to sell. It's a former U.S. attorney. They're going to do it, right? That's why I paid them. I know you're all enamored by that. Well, I'll harken back to something that Judge Boo told us in a video that you can watch. Lawyers are paid to articulate why you're worthy of leniency and why the government's version of events may be wrong. And if that's off-putting to you, Mr. Lawyer, I'm sorry. We're here to speak openly and honestly and help defendants understand the stakeholders. Probation officer, a judge, a warden, a case manager. In our experience, they want to hear directly from the defendant. A federal judge on stage one time said to me, if the defendant is a bad father, you can expect the lawyer to say that he's a good father. If the lawyer had bad intentions, you can expect the lawyer to argue that perhaps he was swept into this and he did not have bad intentions. Who do I believe it's discounted? Now, I've also heard they probably discount to a degree what the prosecution says, because what does the U.S. attorney want? Convictions. They don't want to advance their career because someday they're going to become a defense attorney that you may hire because you're so enamored by it. So if you understand the stakeholders and what their role is, does it make sense that you try to influence them to the extent that you can? In our experience, yes. So in the R. Kelly case, he's convicted at trial, facing a sentencing hearing, and his lawyers, of course, advised him, well, don't say anything. You have other cases. There's an appeal. We're going to appeal this. You're going to win. You're going to prevail. Don't say anything. Fundamentally different than someone then wrong. Throgmorton, who's in our community, who was convicted at trial. The government asked for 14 years. He got 6 years. Ron surrenders to the federal prison camp today in Montgomery. I'll post a video I did with him this week. You can still mitigate and share details of your life without jeopardizing your right to an appeal. Now, I'm not a lawyer, but I don't need to be to know that common sense would dictate that if you've had trauma and ups and downs throughout your life, you should and still articulate that to a federal judge. Tell me how that jeopardizes your right to an appeal. Now, his lawyers tried. His lawyer tried to get on the record that there were mitigating circumstances that should have led to a prison sentence of 10 years versus 30. Specifically, his lawyer said Kelly experienced a traumatic childhood involving severe, prolonged child sexual abuse, poverty, and violence. If true, that's horrific. Here's my question to you. Would it have been more impactful if R. Kelly articulated that to his probation officer and judge? Or is it more impactful if the lawyer is articulating that, not even to the probation officer, simply to the federal judge? And that's the takeaway from this video. The reason R. Kelly, he got a long sentence for a number of reasons. Apparently he did terrible things. He was convicted. He victimized people. He'll be lucky if he gets out of prison alive. And if he does, he'll be damn near 80 years old. This isn't so much about R. Kelly, but it's more about the way that so many defendants continue to make these really tragic, horrific, sickening, disgusting decisions leading up to sentencing. It's part of the reason our phone blows up continually with, I didn't know. I thought I was going to get this. I got that. I didn't think the PSR was a big deal. I thought it was going to be a 7-minute interview. Now the person recommended 8 years. I thought I was going to get 2. Is this normal? What happened? I have a former U.S. attorney who told me it was all good. What's all good? That's on you. So you can learn from R. Kelly, and you can recognize whether you're convicted at trial or you pled guilty. The onus is on you to articulate through your own words what you've learned, where you're going, if there are victims, that you identify with them, what your plans are moving forward. That information aligns with what our team has heard from wardens and prosecutors and judges. You can watch those videos. You still have a chance. Right? Like if you have not been sentenced, even if you've sat for your probation report and you don't like it, you still have an opportunity to make changes. Yet so many people reach out to our team, and you know what they want as I close this video? A do-over. They want another chance. Do-overs don't exist in life. And while today is the best day to begin making better decisions, it's brutal and heartbreaking for many of you who look back and say, I wish I knew this then. But even worse, many of you know it and you still don't do it because you cower, you're afraid to have tough conversations. I'm not indicting all of you. This is YouTube. I presume many of you make good choices. But I know many of you regret the lawyer you hired, the way that you held them accountable, the way you prepared for the probation interview, and then when you learn what to do, you don't do it. And I'm here to tell you as your friend, that's on you. Pain and regret. You can deal with a little bit of pain and some short-term discomfort of having hard conversations. No, my lawyer doesn't want the narrative in the probation interview. Let's push forward. Let's overcome it. Let's get it in regardless. Just don't say, okay, Mr. Lawyer, fine. Ask why. Why? Judges have told me this is beneficial. I've read reviews. I've read case studies. I've heard from people who have articulated the value of doing this. Help me understand why you're against it. Just because you've done it before doesn't mean that it's right moving forward. Help me understand it. That's how you respond rather than cowering. Pain versus regret. It might be tough. Having some painful conversations, it might be foreign to your character and uncomfortable, but what you won't have is the enduring regret that so many of the guys have in the minimum security camp walking around that slow, dusty dirt track talking about the lawyer, the judge, everyone else who screwed them in life because they're afraid to look into the mirror and say, it was my fault. I knew what to do. I didn't do it. If you know what to do, do it. That's how you can learn from R. Kelly's horrific, tragic sentencing mistakes.